to competition concerns, where the seriousness of both such aspects seem to be almost equal. If we are to think about not only the level of the fines that one risks, but also the 21st century, where the privacy aspect and personal data become now the intellectual property jewel of a company. Without further due delay, my presentation contains several slides where my intention was that we would stop and talk about each of them rather than go through the whole presentation and leave the questions at the end. I do count on you to make this an interactive session. This is how it is structured. It goes through the same stages as described so far for an M&A transaction. So we go through the due diligence process, but this time we look at it from both the perspectives, both the seller and the buyer. And then I have selected three practical cases, which when we will describe the facts, I'm sure you'll find them relevant, and we can go from there. So the effort to organize the due diligence process lies on the seller or the target company, or both. From a privacy perspective, for any type of industry that we are talking, so any target, there is a fair share of personal data that is involved and will be included in the disclosed documentation. Whether we talk only about data belonging to employees, company representatives, fiscal documents, and this is sufficient to put a strain on everybody's shoulders. If we talk about the consumer-facing industry, the amount of personal data that flows around is substantially increasing, and the care for the seller to organize the data room dramatically rises. Whether we talk about a virtual data room or a physical data room, one needs to make sure that all the principles are respected and that no data flows unmonitored and unsupervised. If you have to think about this from early stages of privacy, not just from GDPR point of view, because ultimately the privacy principles remain the same. One needs to think about the legitimacy of the disclosure rather than rely on consent. It is not normal to talk about consent, especially in a due diligence process. The target company, the seller, has no intention, has no legitimacy to go and ask for consent. Neither can it do that from a practical perspective. So going from this, we need to rely on other reasons for processing such data. Whether we talk about legal obligations or we talk about contractual grounds, that does not automatically equal to legitimate disclosure during the due diligence process. So that means that we need to be creative, and we need to think whether or not we really need to disclose this data in a due diligence process. With all due respect to competition aspects, from a privacy perspective, I couldn't care less about whether or not you disclose prices or R&D plans or whatever. These are sexy, and for sure, these will interest the buyer. But do we really need to know the personal details of the employees? Do we really need to know their individual salary? Do we really need to know the names of the persons who we sign a contract, I don't think any buyer would be interested to have this information, or in any event, not from day one. So the remedies in a due diligence process would be to make the effort to anonymize the data, make statistics rather than giving the individual information, aggregate data. You don't, that I understand. A buyer would want to know the level of the salary that they are intaking potentially. But an aggregate amount would be sufficient. If not sufficient as a total amount, then you can aggregate amounts per level, per seniority of the employees. Again, even so, some individual data may be needed. Then you can have stages. The due diligence can be organized in several stages. You have access to a certain type of information in the initial phase. In the second stage, certain persons with restricted view, monitored with no copying permission, are granted access to certain information. As I said, the process needs to be temporized, and the process needs to be monitored, and the process, of course, should rely on the privacy effort that was made by the target company and the seller in that respect to implement privacy processes, privacy policies, and ways to undergo even a due diligence process. I will go further if you don't want to discuss this particular slide. We still continue to talk about the due diligence from the buyer perspective. But if you want me to stop, I can stop.
I can speak. Yeah. Okay.
How can you ensure that monitoring of the lawyers or the persons involved in the due diligence process? And really, how do you ensure that the monitoring of their monitoring is GDPR compliant?
Well, it depends whether we talk about a virtual data room or a physical data room. If we talk about the monitoring of the actions of the lawyers, then I'm afraid that in this particular aspect, you need to have a policy to govern the due diligence room, to which the persons who have access to would need to be informed about. I don't think that they need to consent to it unless we talk about video cameras and other security impositions. I believe that this would be contractual grounds enough to monitor their access. We switch to the buyer, who has the task to identify if it has exposure from a privacy perspective. Again, when we talk about the company, B2C company, then the effort becomes significantly higher. For global businesses, again, the effort is double. To start with, you need to figure out what is the applicable law. When we talk about GDPR, the Americans talk about various bills governing industries. I'm not gonna even try to talk about that. Sometimes I find their legislation more restrictive even than GDPR in areas which I wouldn't think about, and in others they are extremely flexible, where in Europe we are extremely rigorous. When a global company operates in both continents, things become a little bit messier. So we need to figure out what is the applicable law. Even though the core principles might be the same, there are fundamental differences which need to be taken into account. I think somebody in the back has made a comment or a question to my former speaker about the level of compliance for certain companies, especially in Romania. I think this is very relevant in the privacy area as well. And this is one of the key aspects for the buyer in a due diligence process. It needs to determine the level of compliance. If you determine the level of compliance, then you can dose your efforts as to how much more you need to investigate and how much more you need to remedy as part of the M&A transaction, whether before completion or after completion. Besides the administrative damage, the fines that we are looking at, again, if we talk about the consumer-facing business, the reputational damage and ultimately loss of clients or profits is equally significant. Failure to identify risks and potentially remedies to them may lead to inability to even use the data post-completion. And if we talk about an e-commerce business, for example, this defeats the purpose of entering into the acquisition in the first place. Cybersecurity risks, which we will see in the practical cases that I selected, are more and more present, and they make pretty huge damages. This may lead to massive data breaches. Data breaches lead to exposure both towards data protection authorities as well as data users, but in the case of regulated industries, this may lead to even greater exposure. In the energy sector, if I'm not mistaken, for example, cybersecurity attacks need to be notified instantly. They may be a threat to national security even. I'm sure in the finance sector, we have other exposure and so on and so forth. If we talk about public companies, again, that will have an impact on the stock exchange and the value of stock. Anyone has any questions? Please.
Yeah, so the question is, if you identify during the due diligence stage privacy risk, so if you identify during the due diligence stage privacy risk, tenders will comply with the GDPR consent. Consent is not allowed.
How do you remedy?
Remedying them before closing, and if you do, would that be what the competition winners like to call gun jumping?
No. We have no gun jumping concept here, thank God. Any remedies that can be taken at any point?
Just to clarify, when the transaction is subject to competition agreements, you do identify and advise on remedying that before closing agreements by competition authorities.
I'm not a competition lawyer, so my answer might not be accurate or relevant. I can only assume that to the extent such remedy has an impact on the competition, fair competition on the market, is not possible. But other than that, from a privacy perspective, I have no issues with that. If any competition lawyer wants to add something, please feel free. Sure. To continue on the remedies, yes, please.
Let's give the opportunity for the lawyers to answer. I think Diego wanted to intervene.
No, I just wanted to ask, I mean, the remedy would be a remedy within the company, so it would be the same company that identifies breach, or would it be like during the due diligence you identify breach of GDPR of the other company?
Yeah.
Okay, so you are buying someone else and you identify that there is a legal issue, let's say, in this. Yeah, okay. Yeah, so you cannot correct that. I mean, and this actually goes back to what Gustavo was saying before. you will have to wait. So you wait a little bit until you complete, and then you correct it.
Correct.
So this is of course what you do normally is you take that into account, of course, in the SPA, right? So in the negotiations, you will say you have this issue. This will cost a lot. This will lead to fines and so on. Therefore, take them out of the cost of the price.
You might
But-
have other opinion there.
I have a question too now.
This question is related somehow. The same answer will be if the question will be, during the due diligence process, we have identified, we as the buyer, we have identified that the target does not have in place an authorization for its environmental authorization. If I'm saying in this period, we need to obtain this is in the same area of environmental,
And I
the
think,
non-jumping risk.
I mean, good. Gustavo, do you want to maybe in your example? I mean, did you have any?
We had a lot of this in the condition precedents. Several.
Because I think this is a very good kind of like.
Yes, environmental permits, extraction permits, cadastral issues, yes. But what's all listed in the, but I don't know if this is a jumping or not.
So it's not in the area of gun jumping risk. It's justified, I need to buy the targets in a legitimate, let's say, environment. So you need to have authorization, and I'm asking you to have authorization. So it's not a gun jumping. It's not like by saying you need to buy something that you are not ordinarily buying. You have to have the authorization.
I mean, it is as Gustavo said, it is a condition present. So you would say, I will not close until you do this, right? But that is just part of the, let's say, the negotiations and the agreement. But then you don't, I mean, the person of course can decide not to sign, of course, but then in addition to that, you are not saying when, how, and so on, and you're not actually doing anything other than checking that indeed that's but that, because I mean, it is a very good point actually. It's because it kind of shows how in any event, whenever you have an SPA, you are of course intervening in what the other subject would do, right? Normally, because under no transaction, this one would not gather some information, would not, I mean, they will of course take the transaction into account. What is important is that it doesn't disrupt the business, let's say, and that you are not deciding how the business is run, let's say. So if you were to say, okay, so first you do this and you ask for this authorization and you get it, this time and you do it this way, you're getting into the business and actually running it, but take into account that first of all, most of the times you don't really need to go into that level of details because it is more a legal liability than just how to do it from a business perspective. And secondly, most of the time the legal authorization is not really let's say, central to the business, to the running of the business. So it would be more kind of a legal issue, a compliance issue than an actual way in which the business would be run. Of course, if you were to say something like you have to change the way in which you run the business in order to be compliant with this specific regulation, you are risking a little bit to cross the line if the changes are significant. So if it is just like you have to modify this and that, comply, get the authorizations, that's it, it's fine. If you have to change completely the way in which you do the business, buy stuff, sell things, hire people, and so on. If it happens not, let's say, pretty much at completion or very close to completion, and he just needs to start doing it when you sign, for example, it is more complicated. That doesn't mean that it cannot be done, of course, because as long as it can be justified, it is okay. And in addition to that, consider that you are, in these cases, I understand that this would be a business that was run, let's say, in an illegitimate way. Let's say, so it wouldn't be, so if it wasn't run in compliance with the law. Let's say this is kind of a good justification, let's say, for the changes and for the agreement and for the commission president. So, but yes, absolutely, it needs to be taken into account.
So, from a privacy perspective, We are not talking about in compliance in the sense that an authorization is missing. In the GDPR era, everything lies on your shoulders. But you may find a company which is completely not compliant or significantly not compliant. And to make it compliant, leaving aside the adjustment of the price and the proper representations and warranties, which you can see on the screen right now, you may want everything to be fixed prior to completion. So you may want to rely on condition precedents, actually. But that would imply more work. That might imply purchasing of software. That might imply employing persons capable of being a data protection officer. That might imply changing your whole organization to implement new processes or other type of processes, policies, so on and so forth. So it might be a significant change. Would that be possible?
So in that case, as long as it's generic enough, so it would be, you have to be compliant with, for example, you have to be compliant with all laws. I don't know how many would accept this in any FDA, but
Sure, it will be specific. It will be
Or
specific.
like,
You know,
yeah.
article of law, you need to comply with that, and for that you need to do that.
that is,
It will be specific.
yes, I don't see any issue, because this is what you're asking is not to do to run the business in a certain way. You're asking to be compliant with the law, so it doesn't come from you. Of course, if you say you have to buy that software and you have to do it that way, you have
No,
to
that
buy
type
this
of software, not
Yes,
that
exactly.
particular
Yes.
software.
Assuming that, well, so if you interpret the law, because this is the risk, right? So one thing is to say you have to comply with the law, and the law article blah 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 requires you to do this and that. One other thing is to say, in order to comply with the law, you have to do this and that, because then it is an interpretation. And I mean, maybe you are very good at interpreting the law, and people would just say, yeah, you are, push the loi, this is what the law says, nothing, you're not adding anything. But some people may try to, put in some other stuff that maybe you like, yeah, maybe you should use this software because it's the one that I'm using, or because it's, I don't know, my sister company making it.
Yeah, but then again, you already tried to interpret and you failed. You didn't do it right, so I'm coming, I'm buying. I would like you to do it right. You did it wrong.
Yeah, but then
So
you
if
are.
I'm letting you doing it as you used to do it, it may be that you're doing wrong again.
I think that would be very difficult to justify, because then you are running their business. You're saying your legal counsel is better, my legal counsel is better, so follow my legal counsel's advice. So that is a little bit more difficult, I think, because then you are actually getting into the business, including like just saying you are not good at doing something, I am better at doing that thing, which is good after completion. Before completion, you're competing with each other, each does its own thing, one is more successful, one less, but you should wait until you're actually the legal counsel to say how things should be run. It's always just to give you an idea, and I think this applies to everyone. This is all subject to interpretation, of course, so it's like you can always go in a different direction, and I mean, there are not that many can jumping cases, but if you're artist, then you get 154 million euros back. So
Similarly, if you don't remedy the breach, you are likely to get the same. So ultimately, I think you need a lawyer. But I think your question now is better answered this time than satisfied.
No, it's fine. Thank you.
Sure. So I think we already covered this slide more or less. Obviously, contractual remedies lie in the share purchase agreement. So whether you have representation and warranties and relative indemnities, or you adjust the price, these are the tools that one has around. If he's not letting us work on the CPs. There are also cases for companies who process data which may be more particular in the situation where you acquire a company, but you actually do not want that company to process data in its own name, to continue to process data in its own name. So from day one, after the acquisition is completed, the company actually processes data on your behalf. You become the controller, you're the buyer. To enable this, advisable would be that you have a transitional agreement in place where you set and distinguish the attributions of each part. The means of processing are clearly spelled out in the agreement. As you know, probably in the GDPR now, by comparison to the previous privacy directive, now you can share liability to a certain extent between the controllers and the processors. So the transitional agreement would be advisable in this situation.
I have a question before we move forward. So you are conducting the due diligence, and you analyze the company seller, and you realize that the company is not GDPR compliant, yet you still want to process data for the due diligence. And what do? You realize, for example, that the company did not fulfill the transparency obligation towards the individuals. What do?
So you realize that the data that is disclosed to you during the due diligence process should not have been disclosed.
Yes. Yet you have it and you process it. What do you do as a buyer?
Well, I don't process it to start with.
You do.
I can't. If I realize that I am in a weak position, then the first thing that you need to do is to stop, and you need to withdraw yourself from that position. That's my advice. Of course, I think your question is, what do you do with the data that already entered into your possession? It's a tricky situation, and you shouldn't have gotten yourself into that situation. And from that perspective, I think you have to look at the way the data room was organized, and the rules that govern access to the data room, and the rules that govern disclosure of data by the seller to the buyer. And you need to be satisfied with that privacy policy. In the end, you have an exposure because that data has landed in your lap, but it's a situation which shouldn't actually backfire on you if you took all the necessary precautions.
Would it be advisable for you to go and, let's say, you receive the information from your a third party information? Would you go and inform the people that the data is processed, or do you think that's a risky operation?
As a general advice, I cannot say yes or no. I would consider, depending on how big is the breach, that's ultimately the exposure. I would consider discussing it with the relevant authority. Yes, if I have a significant breach.
So you think you look at it as a breach,
ultimately it's
right?
not my processing.
You look at it as a breach, yes.
It is a breach. If I have a mass disclosure of data, which shouldn't have happened, that is, it is a breach. If I don't have the legitimate purposes for it, it's neither a legal processing or a contractual processing, does not have consent, it's a breach. I have selected 3 case studies. There are only 4 fines applied so far by the Romanian Data Protection Authority, and from the ones that that have happened, this one stands out. Not just for me, at least, not just in terms of the value of the fine applied, which by comparison to fines applied by other EU jurisdictions, but for Romania is significant enough, but also from the perspective of the breach itself. I'm going to read the facts. The facts are that the surveillance authority has received a complaint that one significant bank in Romania is actually disclosing personal details of the payers to the other end, the beneficiaries of the ones who receive the payments. So specifically, the national codes appear, or the address of the persons who instrument the payments appear in the bank statements of the persons who receive the payment. Further to this complaint, the surveillance committee has went on and audited the bank, and it turned out that, or at least this is what they were fined for, it turned out that there were no adequate technical and organizational measures applied, both in terms of establishing the means of processing, as well as when the actual processing of personal data occurred. I was trying to make an effort of thinking what would have happened if such a breach would have been discovered during the due diligence process, and how you could have mitigated against it. And in my view, reviewing the internal privacy policies might have been insufficient to identify this issue. So one would probably need to look in the GDPR audits that have been performed by the bank for sure, I'm thinking, before the GDPR entered into force, or even data protection impact assessment. But then again, one would expect that during such audits or the PIA processes, such issues would have been signaled and remedied, which means that the alleged buyer should have looked even further in substance, which would mean that they would actually have to redo the audit and the PIA, and the whole process would have needed to be restarted, including the review of payment policies and including interviews with the relevant personnel. That is not something that one would expect to do in a due diligence process. But then again, this time the fine was 130,000 euros. I don't know what would happen next time. Definitely, it wasn't nice for this bank to have been the first to receive such a fine. But any other thoughts?
I was thinking if Partner Simion would have been in that position, the fine would have been tripled because they have more than a million customers in retail, and they are proceeding the same. Until the fine.
Well, I am actually using VR, actually, Ana Maria Simion and Cosmina are using Banca Transilvania for business, and nowadays at least, details do not appear. But I'm contradicting you because we are new with this bank.
They were doing the same. They don't think that transmitting the personal number is data breaching. It's considered data. For them, it was just normal business.
Well, probably after this fine has been applied, they changed their processes. But to be fair, there was one instance when this annoyed me, the fact that I do not have the details of the person who paid me, because the payment was wrongly done to a wrong account. So I would have needed to send the money back, and I wanted to do it automatically. But I couldn't, of course, because I didn't have those details. So I had to reach out to the data center and ask for those details. But that was just a joke. Obviously, you wouldn't want such details to appear in your bank statement, in the bank statement of the person that you work with. We're going to go more international because I couldn't find anything else in Romania. Marriott is facing, or has been threatened by the ICO in the UK, to be fined with almost 100 million fine. It remains to be seen what will happen. And this breach appeared from, I would call it an improper due diligence. Because what happened is that Starwood Hotels IT systems were compromised in 2014. Marriott acquired Starwood in 2016 and only notified this data breach in November 2018 and admitted that personal data, including credit card details, passport numbers, and dates of birth, has been stolen in a global hack of guest records. On July 9th, the Information Commissioner had issued this public statement where they announced their intention to fine Marriott International with more than 90 million pounds under GDPR for data breach, stating that 339 million guest records were exposed globally, of which around 30 million related to residents in the European space and 7 million UK residents. What is even more interesting is that their statement says, and I quote, the GDPR makes it clear that organizations must be accountable for the personal data they hold. This can include carrying out proper due diligence when making a corporate acquisition and putting in place proper accountability measure to assess not only what personal data has been acquired, but also how it is protected. So things get serious. I don't know why Marriott didn't discover this 2 years after the breach occurred. I don't know why Starwood Hotels didn't remedy this by the 2016, and definitely I don't know why Marriott had only notified the breach in November 2018. But this is where we are today. And this is a very interesting case which I knew about for ages. It happened before the GDPR era. So it was more or less the impact happened in the US. If we were in the GDPR era, I'm sure things would have been different since we talk about Yahoo. And I, for once, have a Yahoo account. I'm pretty sure it was hacked, so I changed it to Google. And now France is fining Google. We'll see how that ends. Facts are that in December 2014, Yahoo faced the largest known theft of users' data at the time. Hackers allegedly stole what Yahoo called its crown jewels: usernames, email addresses, phone numbers, birthdays, hash password and security questions and answers for more than 500 million accounts. Yahoo only disclosed the breach publicly 2 years later. Yahoo actually didn't even inform their external counsel, they didn't inform their European branches, they didn't do anything, and falsely represented that it had no data breaches in its stock purchase agreement with Verizon Communication Incorporated, which was also publicly filed, because this was the obligation, with the SEC. The impact is that Verizon enforced its contractual clauses and acquisition price was diminished with $350 million US. And Yahoo also faced a suit from its shareholders, which it ultimately settled with 80 million because Yahoo didn't even tell its own shareholders about the data breach. In addition, the SEC claimed that the legal provisions were breached in the sense that by its failure to properly disclose, coming from the misrepresentations in the publicly disclosed agreement with Verizon, Yahoo's investors have been materially misled, and as a result, fined Yahoo with $35 million. I don't know what Verizon could have done more. Obviously, they did something well. They had those contractual clauses to protect them. I don't know what Yahoo has thought or its management, but this is what happened in the end. This is all I had to share with you today. There are many other cases, of course. We can talk about Facebook, we can talk about Google, we can talk about whatever we want, but it seems that every day now something appears. And I am talking about privacy in the cybersecurity environment as well, because hackers seem to haunt any company which makes use of data. And this data belongs to us. Thank you.
And please, if you still use a Yahoo email address, 60% of the Romanians do, please change your password, at least that. So, and with this, we go into the coffee break. We have a 15-minute coffee break, just to reduce with 5 minutes. So we'll be back at 6:20 because we have 2 more presentations coming up.